I was going to
Why don't
follow
you
up
go
on
ahead,
this.
Justice Sotomayor.
Justice Alito's question assumed a jury waiver, a jury instruction waiver. Did you waive here?
Well, I don't think we've waived anything. We preserved all the way through our objection that the right to control doctrine is not a valid theory of fraud. That's preserved at page 103 of the JA. The Second Circuit dropped a footnote and said the defendants challenged this theory. We don't have to reach it because it's settled Second Circuit law. And it used that theory to analyze the sufficiency of the evidence, and that's the theory, the only theory, on which the Second Circuit found that the evidence is sufficient.
So you say you object that's preserved your jury instruction.
That's correct. Well, I want to be clear, Justice Sotomayor. We're not talking about the jury instructions on our theory of the argument. What we are talking about is the sufficiency of the evidence and the legal standard that the Second Circuit used to find the evidence sufficient. It used an incorrect standard based on right to control. That's the only theory that it used to examine the sufficiency of the evidence. Because the evidence is not sufficient to prove property under that theory, an acquittal is mandated. And the government's tangent has brought up things that require me to talk about the indictment and the jury instructions, because it's not, Justice Alito, that we're asking you to resolve a constructive amendment theory. It's that the government's theory would create a constructive amendment. It would change the language of the indictment back to the S1 indictment after having dropped that and put in the S2 indictment a right to control theory. And we're looking at the jury instructions only to answer the question, did the jury resolve the question that the government is now putting to it under its fraudulent inducement theory? And the answer to that is clearly no. The property differs. The government won't dispute that. Instead of it being the right to control assets, it migrates over to become the contract funds at the end of the day. The government offers a new materiality theory that says that the misrepresentations have to go to the essence of the bargain. There's nothing in the jury instructions that contain that amorphous characteristic anyway. The jury didn't decide that. And the government offers a slant on by means of, that the acquisition of the property or the obtaining of the property has to be by means of the misrepresentation, that borrows from this court's decision in Loughran to say that it has the natural tendency to induce the person to part with property. That also was not in the jury instructions. And critically, the defense has defenses on both of those issues that it was not given the chance to litigate because that was not the theory of the case that the government went forward on below. On the essence of the property, the essence of the bargain requirement that the government now offers, it is highly significant that at page 47 of the government's brief, the government says that a fair exchange can negate the materiality under its essence of the bargain theory of a misrepresentation.
Well,